Good morning, ladies and gentlemen. This is the City of Ormond Beach Special Magistrate hearing for February the 27th, 2023. I'm Senior Judge Pope Hammer, who's been appointed as a Special Magistrate for the City of Ormond Beach. And I'll tell you how we will conduct the hearing, and then we will begin. I will call the cases. Today we have 4 cases. One case is the same respondent for 3 cases. We have a 4th case, which I think will be fairly quick under old business number 4, and I'm going to call that first. We have 3 cases with the same respondent, and do you desire to take these individually?
I would like to do all of 3 before the respondent gives her,
Okay.
like, up to recommendation.
Okay.
For each.
Are you the respondent?
Yes, I am, Your Honor. Is that okay with Your Honor?
Yeah, it's okay. Is that to make a record of what he's doing there for appeal purposes?
Yes, Your Honor.
Yeah, okay.
Your Honor. I realize you haven't formally called the case just yet. Once you've done that, but before we go into any factual presentation, I have a matter of law to bring up with you that would precede that.
Well, that's fine for you to have a matter of law, but I would prefer to do it this way. I will call on the city for their testimony as why the violation occurred. Then you may respond to that, and then you can give me any case law you want to at that time. That's the way I'd like to conduct it.
I understand that, Your Honor. I guess my concern is, first of all, that I was handed all the evidence about 9:58 this morning, and the statute clearly requires fundamental due process. I also have received no confirmation from them that they have submitted to you the materials that I submitted ahead of time. And besides all of that, in my materials, I mentioned that this case was actually brought illegally because Florida Statute 70.45 required them to issue a written response to me as to why they feel that I have caused a harm by these supposed violations, and how their proposed regulation is proportionate to the supposed harm that I've caused. Before they can continue with that, they are legally required to submit an answer in writing to me, unless they submit in writing to me something saying that they're no longer going to be pursuing that. Instead, they've totally ignored that. So this proceeding was actually commenced illegally. That's why I wanted to bring that up before they had the chance to continue with this, because it violates due process.
I will allow you to do that. We're at a limit for time. There are other matters that I will do this afternoon, and so I have to conduct the hearing the way that I think that it should be conducted. As far as the material which you had, that it was delivered to me Saturday about 2:30, and I had reviewed all that.
Okay, thank you, Your Honor.
Now, so specifically, you feel the hearing is not appropriate to be brought. Is that what it is?
That's one of my concerns, yes, Your Honor. That would be the concern that I feel it would need to be addressed at the onset of the hearing rather than bringing that up in the middle.
Yeah, okay. We will proceed with it.
Do you want me to, I didn't know if you officially called it yet, so I was just waiting.
Yeah, I'll call it. I think I already spoke, but I'll call it. Case number 22-11223, parcel 4223020600130. Michael Henry and Katherine Henry, P.O. Box 333, Ormond Beach, Florida. Location of violation 33 Cypress Circle, Ormond Beach, Florida. The alleged violation is no building permit issued as stated in the Land Development Code, Chapter 2, Article 3, Section 250N1A. Fence installed without permit. The second case is case 22-112 246, parcel 422303060130. Michael Henry and Katherine Henry, P.O. Box 333, Ormond Beach. Location of violation 33 Cypress Circle, Ormond Beach. No building permit issued as stated in the Land Development Code, Chapter 2, Article 3, Section 250, storage containers placed on the property without a permit. Third case is case number 22112247, parcel 422302060130. Michael Henry and Katherine Henry, P.O. Box 333, Ormond Beach. Location 33 Cypress Circle, Ormond Beach, Florida. Violation, no building permit issued in the Land Development Code, Section 114.6A1, pavers installed without obtaining a permit. The respondent, Katherine Henry, is requesting the special magistrate to hear arguments that the city does not have the authority to proceed with this hearing. So I will allow you to do that now. What will you be doing? Submitting cases to me?
No, the statute I already submitted to you, Your Honor.
Okay, all right, I've read that. And then the city can respond to you. Pertaining to what happens there, then we'll proceed. Okay.
Yes, Your Honor. Aside from the other legal issues that would be more relevant to talk about in the regular context of probably after the city has presented any evidence or arguments that they would like to present, the issue of this hearing starting and being set for a hearing is in violation of Florida Statute 70.45. Looks like I have a typo. It's supposed to be 45, not 445.
Say that again.
I just realized there's a typo at the beginning of my documentation I submitted to you. It's Florida Statute 70.45, not 70.445.
Yeah, okay, I see that in your
so I apologize for that. So the issue here is that with that statute, I mean, there's tons of Florida statutes that talk about why the proceedings in this manner shouldn't be going forward. And why our protections as homeowners are of the utmost concern with the legislature and how they have set out the Land Development Code and all the other related statutes. 70.45 specifically created a situation where if a homeowner, such as myself or the two of us, my husband and myself, think that the city is violating our rights as property owners, then we can file a written notice of proposed litigation or proposed action to the city, where they are legally required by the statute. They must respond in writing with one of two things. They either have to respond in writing saying, we have decided that it's in the interest of justice, that we're not going to pursue the case, and so we will take no further action in this matter. Or they have to respond in writing saying exactly what harm it is that our proposed use of our property has caused and how their proposed regulation of our property is proportionate to the harm that we're causing. There is no harm that our property is causing or our proposed use is causing, nor has it ever been alleged, because it's simply not the case. But instead of responding in writing as they are legally required to do, they instead instituted these proceedings and acted as though that statute didn't exist. They're cherry picking which laws that they're going to follow. And this is literally the statute 70.45. This type of hearing is precisely the municipal regulation that the state legislature says you have to put pause on what you're doing and provide this written response before you do anything else. And that way, if they respond in writing to me saying, oh, well, we think we have reason to do this because your 3 proposed uses cause harm in some way, and here's how they cause harm, etc., then I have the opportunity to, among other things, file a lawsuit against the city to stop them from pursuing this. But they did not afford me that opportunity and because there's not a specific deadline, I've been patiently waiting for the city to file their statutorily required response to me. So it would be premature for me to have filed a civil lawsuit against the city at this point. So this is really the only thing that can happen at this hearing, is that they be ordered to follow the Florida statute and file that written response to me, which, depending on what the response comes out to be, then I have the opportunity to follow the statute and file a civil case in the county circuit court. Otherwise, this hearing would be premature, and it would literally subvert the entire purpose of Florida Statute 70.45.
Can you refer me to sections in 7045 that you think are pertinent?
Sure. Give me a second, Your Honor. I must have already pulled it out.
That's okay.
Um, 70.45, I mean, really, the whole statute, it's not very long. The whole statute is relevant, so I'm not sure exactly how to best answer your question.
Okay.
But it starts with the definitions section, and this kind of thing would be a prohibited exaction, which is any condition imposed by a government entity on a property owner's proposed use of real property that lacks an essential nexus to a legitimate public purpose and is not roughly proportionate to the impacts of the proposed use that the government entity seeks to avoid, minimize, or mitigate. Obviously, attorneys wrote that because it's horribly complex, but that is what we're talking about, is prohibited exaction. And sorry, that was subdivision 1D. Subdivision 2, in addition to other remedies available in law or equity, a property owner may bring an action in a court of competent jurisdiction under this section to declare a prohibited exaction invalid and recover damages by a prohibited exaction. And it says that at least, this is subdivision 3, Your Honor, at least 90 days before filing under an action under this section, but no later than 180 days after the imposition of the prohibited exaction, the property owner shall provide to the relevant government entity written notice of the proposed action, which is what I did on November 8th, 2022. This written notice shall identify the exaction that the property owner believes is prohibited, which I did. It's the 3 regulations we're talking about here today. Explain why the property owner believes the exaction is prohibited, which I did, and provide an estimate of the damages, which was attached. The government entity shall review the notice of claim, shall obviously is a requirement, and respond in writing to the property owner by identifying the basis for the exaction and explaining why the government entity maintains that the exaction is proportionate to the harm caused by my proposed use of my real property, or by proposing to remove all or a portion of the exaction, or in other words, dismissing the action against me. And even if, in the event that they wrote back and said, oh, well, sure, this is the harm that you've caused, and this is how our exaction or regulation of your property is, we believe, is proportionate to your loss of use of your own property. Even then, if I decide to then file that civil lawsuit against the city, the government, the city entity, has the burden of proving, even in that action, that the challenged exaction or the regulations that they've brought up here has an essential nexus to a legitimate public purpose and is roughly proportionate to the impacts that our supposed, our proposed use of our property, that they're trying to, the harms that our property is supposedly going to cause. And that's, I guess, something that's telling is that it's the government entity that bears the burden of proof in that sense. And the whole thing is, that goes to the point of 70.45 is written for a reason. We can't cherry pick which laws we're going to follow, which has been a problem in this case all along. But this one stops this proceeding from even taking place. So they have to respond in writing either way, and the statute is written so that if they respond saying, oh, we think we're legitimate in our, we're going to continue with this, then they have to lay out what harm I'm causing and why they think the regulation is proportionate to my loss of use of my property. And then I get to be able to file a civil lawsuit against them where they have the burden of proving that those conditions exist. So it's, are all of our statutes complex and complicated and found in way too many portions of Florida statute chapters? Absolutely, but that doesn't mean that we get to cherry pick which ones we're going to follow, and I followed this statute to the letter, and I would expect that the city has to do the same, Your Honor.
Okay, that's interesting, and I appreciate that. You're an attorney, so...
Not a Florida attorney.
You're not a Florida attorney. Anyway, do you know what a judge would ask you? Do you know of any district court cases in Florida or Supreme Court cases that I could look at pertaining to this argument that you're making?
This specific statute, or... No, because I think that's not our job. When it comes to implementing the statutes, we have to implement them on their face. We can't simply ignore them. And that's the thing, is that when this has been brought up to the city for almost 4 months now, 4 months, never once have I received a response either that they thought the statute was not appropriate, or I've received literally zero response on this at all. The only response I ever got was when they were serving me with the notice to be here.
Okay. All right, thank you. Is there a response from the city?
Yes, Your Honor. I haven't had an opportunity to review the full statute that she's mentioning, but it appears that this is the wrong forum to be arguing the application of this statute. That would be before the circuit court. This is not new legislation for the local government. This is not something that was created and now is affecting her rights. I believe she has lived in Ormond Beach no more than 2 years in this property. These ordinances have been in effect long before this. All these codes have been held in court. So she moved here with full knowledge, and she has not gone to circuit court to challenge these ordinances or code in the city. So I don't think she's in the right forum. There's no standing for this.
You want to respond to that?
Yes, absolutely, Your Honor. The problem is I wouldn't have standing to have filed a lawsuit against the city before this because there wasn't a government exaction under this very statute where they were attempting to do what they're doing right here. It would have been kicked out because it would have been premature. The only way that, it's pretty clear. And not having time to read the statute, it literally takes up 1 page, and they've had notice of this for 4 months. But this statute is pretty clear. It's not challenging necessarily a particular statute that it's, unconstitutional on its face. Maybe it's unconstitutional as applied. There could be all kinds of reasons why the proposed exaction is not appropriate under the statute. But that's not what the purpose of that statute is. And the statute doesn't mean that I have to then go and bear the burden of proving that a particular code is unconstitutional, either as applied or on its face. That's not the purpose of that statute. In fact, the statute is pretty clear that when they're trying to do this very thing, when they're trying to stop, look at what I was just served this morning, their proposal for if you should find in their favor what they're asking you to do, and just like the case right before us, they're asking that you issue the per day fines, and that you allow them at as of April 10th to go in onto my property, removing my property. That's the epitome of. It makes no sense to say we have to go through all of this before I would then go and file a lawsuit. In fact, I have to file the written notice to them of the proposed litigation prior to going and filing the actual documentation in circuit court. Otherwise, they'd kick me out. They'd say, well, you didn't comply with the requirements. I did exactly what I was supposed to do, and the city, because they have absolutely no experience or know-how in dealing with 70.45, decided that they're just not going to touch it. They're just not going to deal with it. But that's not how this works. We have to uphold all the statutes.
Okay, so your argument is in the nature of a motion to dismiss this action. Is that correct?
Yes, Your Honor.
All right, anything else from the city or from you arguing in this case? And a lot of the things which you have talked about are in your response, which I thoroughly looked through.
I guess just to clarify, Your Honor, the only thing I would say that I would be asking then in terms of looking at it as a motion to dismiss is that it be coupled with the city still has to respond one way or another in writing to this notice that I have served them. So I would ask not only that this action be, all three of these actions be dismissed today, but that they actually be required to submit the legally, statutorily required written response.
Okay, thank you. All right. After reviewing your written response and after hearing arguments, after hearing from the City of Ormond Beach, I find that your arguments are without merit, and I deny your motion. And I'll proceed now with the testimony of the City of Ormond Beach. So who is going to testify?
Your Honor, I'm going to object to the pictures that are up there already, though, because those were obtained illegally when the city went on my property without a warrant and took pictures. So they shouldn't be used in this proceeding.
It's denied. May proceed.
Good morning. My name is Janet Bruce, Neighborhood Improvement Officer for the City of Ormond Beach. It's a case before you.
You know what? You're going to have to speak. I'm not hearing. Can you move close?
Can you hear me?
I sometimes like the two seats over here. But
My name is Janet Bruce, Neighborhood Improvement Officer for the City of Ormond Beach. The case before you is case number 22-112237. The respondent is Michael Henry and Katherine Henry. The violation address is 33 Cypress Circle. The violation of Land Development Code, Chapter 2, Article 3, Section 2 through 50, N1A, fence installed without a permit. I would like to submit into evidence a copy of the notice of hearing and a $100 citation with proof of good service, copy of the notice of violation with proof of good service, affidavits for regular mail and posting, copy of property appraiser's record, a copy of the Land Development Code that is at issue in this case.
any objection? Admitted.
Yes, Your Honor. What I was actually trying to do is figure out which, I would have been a little bit better prepared had I been handed this
I
before.
believe we're talking in the case number 1, the 22-112237, correct?
Yes.
And there's two, I was handed two different packets that were stapled. My question is, are both of those being presented right now or just the first one?
Just,
I wanted just the first one to be
just
just the first one.
Okay,
the photos have not been submitted yet.
okay. Yes, sorry, give me just 1 second here. I don't think I have. Was the sheet with the costs, that's not in that one? Okay, no, I don't have any of them.
She is presenting her case as to number 1, why she feels as a city representative that the building permit fence installed without obtaining a permit. And so that's the only one she's dealing with right now as far as.
Yeah, that one case has two packets that I had been handed before the hearing, but I realized that the issues that I had that I'm objecting to are mostly in the second packet, so what you've been handed so far I do not object to.
Okay, admitted into evidence as a composite. City's exhibit number 1.
I would also like to submit photos which led to the issuance of the notice of violation and citation, photos of the last status of the property which reflect the current state of the property, as well as the case cost sheet. in the recommendation page.
So you are asking the magistrate to admit into evidence the beginning of the construction of the fences there, and then a date showing the fence has been constructed.
Yes, sir.
And that fence is still there, correct?
Yes.
Okay, I want to take a look at these. See what. Any objections won't be admitted?
Yes, Your Honor. I have a few different objections. My first.
No, I'm asking the objection for this particular composite right now.
Yes, and I have 3 different objections to this composite.
What are the objections to this being admitted?
The first objection I have is that these photos, at least in part, were taken when she went onto my property illegally without a warrant and took photos. Some of them were taken from across the street, but some of them were taken from being on private property, both mine and a neighbor's, without a warrant, and even squeezing in between vehicles that we had to go further back into our property, and to take photos that would otherwise, essentially, I guess, be fruit of a poisonous tree that she could not have done. Even law enforcement wouldn't have had a right to take those photos because there was no warrant.
So you want to respond to that?
Yeah, Janet, were any of those pictures taken, were they all off the property?
Yes, ma'am. I was standing on the sidewalk.
Your Honor,
Wait till I.
sorry.
Yes, Your Honor, I just want to clarify that none of those were taken while she was on the property.
I was standing on the sidewalk.
Okay, you can respond.
See, this is why it would have been nice if I had due process and was given this ahead of time, because I have video footage, which I alluded to in the documents, in the notice of proposed litigation. They received this 4 months ago, knowing that I have video footage of her being on our property. In fact, you could see, just to give you an example, is it on a different? I know, just a minute. I have, the one photo that shows from the, that the photo itself shows that she was on our property isn't part of this packet, but I have video evidence. I have video evidence that shows that she was on our property and on the neighbor's property to collect these. I don't believe that, I'm not sure if it was the gentleman next to her or whoever was with her that day. I don't believe he was, but the video footage certainly shows that she was on our property and even walking between our vehicles to take pictures that day. And I did put them on notice. They've had 4 whole months, and I didn't have the photos to know what it is they're going to try to claim as evidence later as fruit of that poisonous tree.
Okay. Of course, your argument is still going back to the motion to dismiss this action that you made, which I have already denied.
No, that's a separate motion, Your Honor. I mean, that's a distinct.
So the it is admitted as City Exhibit 2 as a composite.
Oh, Your Honor, I had 2 more issues with what was in there.
Okay, what are they?
Also, as part of this, Florida Statute 162.07 subdivision 3 says, although the formal rules of evidence shall not apply, fundamental due process shall be observed and shall govern the proceedings. Again, I wasn't given an opportunity to know that they were going to try to use these photos so that I could have brought to you my video footage to show you how she was physically on the property violating my rights in taking these photos. But also, when it comes to the recommendation here and the fact that they're going to be, they're asking you to, in the end, if we don't remove our own property, for them to be able to come onto our property and remove that there's no reason why that information wasn't submitted to me earlier either. And again, the statute clearly requires fundamental due process. there's no reason why I was denied due process in knowing what they were asking for. And in addition to that, although she hasn't talked about the costs yet, the costs included in the sheet that she has that you would later have more discussion and rely on, I would object to because it's the same for all three. So they're tripling up. So let's say you decide you're going to award costs on this one file. The costs would not be this. They can't be then awarded on the next two cases because there were not 9 certified letters sent to me. I don't know if that makes sense.
Okay, so you want to respond?
I think we can just get to the cost matter later when we do the costs, and Janet can explain that those are treated as individual cases, and so they aren't just an overlap.
The magistrate's going to enter in the city's exhibit as possible. All right, you may proceed.
I'd like to present the photos that are an issue with this case. This is the initial photo that I took on 9/1/22. They were in the process of building the fence. This was taken on September 2nd, 2022. I did issue a stop work order for all 3 cases that are at issue here on September 2nd, 2022. This is September 13th, 2022. After the stop work order was issued, they continued to attempt to finish the fence without a permit. That's September 13th, 2022. And this is the most recent photo taken on February 21st, 2023. The fence has been completed without a permit from the City of Ormond Beach.
Other than the fact that they did not obtain a permit, what's wrong with the fence? Anything?
The orientation is incorrect.
I can't hear you.
The orientation of the fence is incorrect. The fence is built backwards.
The what? Tell me again.
The fence has been constructed backwards. The good side is on the inside rather than the outside.
Okay, do you have any other documents to be presented into evidence in this case?
Not for this case, Your Honor.
Your Honor, if I may also just clarify, because no permit was applied for, there's no way that the city really knows without going onto the property if it's also the proper height and if it meets setback requirements.
What is your recommendation in this one case?
I recommend finding that a violation of the Land Development Code, Chapter 2, Article 3, Section 2-50 N1A exists, and that the respondents be ordered to pay the $100 citation as well as the associated case costs and shall comply with the code by March 27, 2023. Compliance shall be achieved by obtaining an approved fence permit and pass a final inspection or to remove the fence from the property. Absent compliance, I recommend a $25 per day fine be imposed beginning on March 28, 2023, and shall continue to accrue until compliance has been achieved. Further, the respondent shall be obligated to contact the City of Ormond Beach Neighborhood Improvement Division to schedule a reinspection of the property to confirm compliance and date thereof. Absent compliance, I request that the city be granted the authority to enter onto the property on or after April 10, 2023, and have the right to remove the unpermitted fence from the property with all costs thereof to be assessed against the respondent. In addition, should the city remove and dispose of the aforementioned fence, the city shall not be responsible for any damage or loss associated with said removal. You want me to go to case costs or?
Case cost?
Yes. The current case cost on this case is $23.56. This is the breakdown. Each case is issued its own individual certified letters. They are not sent together in one packet. They're all sent individually as their own case
Okay, now that's the city's recommendation. Do you want to make arguments to that?
I do. I also have, yes, Your Honor. With regard to the stop work order, there was no stop work order legally issued. When she spoke with me on the phone that very day that she's claiming that she put those out there, she mentioned nothing about a stop work order being issued. She ended up emailing me some information later that day. Again, she mentioned nothing, gave me no copies of any kind of stop work order via that email, it wasn't until later that I found out that although she knew I was home, my car has my name on it, it's right by the front door, and she had just spoken with me on the phone and she knew I was home, she decided to come out and put the signage in the boulevard of the property, not on our property and not even facing our property, so only the neighbors had notice, not us, and she put it up in a way where I want to say there was only like one staple on the thing, and we had a really bad rainstorm later that day, so before I even saw that there was a post in the yard, the sheet had fallen off and we didn't find it until much later, and then that made sense as to why we had a random stake in the yard. So that would not constitute any kind of providing us notice or any kind of fair play, if you will, in any of this at all. There's no reason not to have simply knocked on the door and handed it to me or taped it to my front door or anything, anywhere on the front porch. None of that happened, let alone, like I said, in the phone call or the email was anything mentioned about that at all. But there's a bigger issue, and that is the cherry picking that's happening. It's a definite equal protection violation. We did move here fairly recently, still getting to know our neighborhood and the City of Ormond Beach in general. And so as we've been walking through the neighborhood, just being able to see with our own eyes, in an area that's just, I would say, our immediate neighborhood, just barely over a quarter mile squared, there are numerous examples of fence violations. In fact, there are six.
Is that what this part is?
Part of that is, yes. The color-coded spreadsheet, my printer doesn't print color, so I don't remember what the color was. Mine's gray. But there is, at the beginning, the first column separates out just general permits not having been issued for extensive remodels, that I think is maybe in blue. And then there's a section on pavers and a section on fence. It's specifically about the fence that I'd be talking about.
How did you determine your cherry picking chart? Did you go through the neighborhoods and look to see where you thought there might be violations, but nothing had happened there? I'm just curious about
Yeah, it's just something that, as I regularly walk my neighborhood, and it's as this situation arose, and I read the entire code, I looked around and I'm like, this doesn't seem right, because we've seen all of this, and so I decided to give them just a few examples in the notice that I sent them in November. But since then, it's kind of one of those things, you know, when you first buy your first white Toyota Camry or whatever, and then you all of a sudden everywhere you go you see white Toyota Camrys you never really noticed before. It's that kind of situation, Your Honor. So as we walked our neighborhood, this isn't me, you know, hanging out in the backyards of my neighbors or anything like that. This is what you can visibly see of violations happening. What is that? Okay, sorry, just want to make sure. These are ones that you can visibly see, but there are just within that quarter square mile, which we're talking about is less than 1%. It's 0.7% of the City of Ormond Beach. We're talking about 63 other documented examples that I'm able to just see of issues where the fence, land development code as it pertains to the fence, are being ignored.
So you did a very good job here, but how would you specifically know that there was not a permit or there wasn't a variance in a particular property where you thought there might be a
Because
violation?
those records are online.
Uh-huh.
And
So
some of the
that's-
issues-
That's the way you looked at them?
The records are online, yes, but when it comes to, we're talking about the wrong height or opacity, those are things that you can see. I mean, as far as variance, none of those appeared, but dilapidated fences, I couldn't imagine that there would be a variance for a dilapidated fence. But at any rate, and obviously when I put my initial document together, we hadn't had the second hurricane yet, and we live beachside. So the amount of violations would actually be staggering, but it was too impossible to keep up with all of that because my neighbors, literally every single neighbor around me, even Pizza Hut on A1A, everybody had at least a portion of their fence that had come off, if not had a total decimation of their fence. And quite a few of those neighbors have already been putting them together, which total more than 50% of the lineal footage of that fence, which triggers the permit needing to be required. And this isn't just neighbors. This is, and like I said, these 63 examples, that's in less than 1% of the entire square footage of our city. But these very types of fence violations are also found at 39 Byron Eleanor, where a city work van, it must be a city employee, lives there and parks the work van there every day. And that's already been in your packet. Ormond Beach PD regularly parks at 52 Byron Eleanor, which has had, since the hurricanes, their fence was totally torn down, which I have pictures of that, and submitted that in there to you. And they have a whole new fence, and there's no permit for that. And the city knew about a lot of those violations because there were 4 other permits that were pulled in 2022 for various other things on that property, not to mention that there's a Ormond Beach an Ormond Beach officer that regularly parks at that property, but also several of these other instances. So it's it's absurd to me that we can cherry pick and go, well, Ormond Beach PD is going to get a pass. Ormond Beach city employees can get a pass. Ormond Beach, whatever government officials that I have in the example for you can get a pass. Or 63 other examples just that I've documented of fence violations alone, they all get a pass. And not to mention when you multiply that by the 0.7%, I mean, the numbers are staggering. And how that doesn't demonstrate an equal protection violation when I am 100% unequivocally guaranteed equal protection under the law,
Okay,
I wouldn't know what
let me
it is.
stop you 1 minute about your argument on the cherry picking. You've done a lot of work on that, I can tell. I've been the magistrate here for 18 years. Before that, I was a judge for another 20 years in Volusia County. And almost every other time I come here, someone will say, you're treating me like you're not treating this person. There are other violations that go on, and you should not be doing things to me because you're not doing things to these other people. So I say to them, can you refer me to a case that went up to the district court or the circuit court or something to say that this argument of cherry picking is substantiated? And I haven't got very much, to tell you the truth. I have to comb my mind into this particular one. Now, if you don't win in this case and you appeal it to the circuit court and they substantiate that argument of cherry picking, I would be most interested to know about it. Is your argument for this particular one going to be the same in the other 2?
Some.
Yeah.
As far as, I don't know if I'm cutting you off, Your Honor. I had other things to say about the fence issue besides the equal protection issue.
Okay, well, you understand that I'm not buying the cherry picking argument.
I still have a right to place it on the record because
You do have a right, but I have a right to continue with my hearing, and when I think I've heard all that I want to hear on a particular item, I can tell you that to go on to something else. So let's go on to another argument that you
Well, yes, Your Honor, that's what I was just about to do. When it comes to the costs, I don't know why mine looked different, but mine looks like that you now are seeing in front of you. I do acknowledge that they send the certified letters in a separate envelope for each of the three. But we were, first of all, I shouldn't have to, there were three, there's a hearing today, right? We have a hearing, there are 3 cases, that would be 3 certified letters. But you could see there's 3 listed just for that one alone, plus another copy sent by regular mail, which I don't know why that would be a cost to me. But the other cases as well, there's an exact same sheet. So in the end, they want to charge me for receiving 9 certified letters. There were not 9 certified letters sent. There's 1 for each case.
Well, they have a procedure which they have to put cost on each case.
Oh, I get that.
When it comes to me, I can decide what I want to do as far as whether I want to order the cost or not. So
I'm just saying, if as far as certified mail goes,
Yeah.
it shouldn't be 3 on the screen we're looking at. It would be 1. And the regular mail, I don't know why you would send regular mail when it's already sent by certified mail.
okay, I understand your argument.
That's all I have, Your Honor.
Okay, so I'm going to wait till we do all 3 before I make my findings and determinations. So let's go to the next one. Anybody want a break?
I was going to ask the respondent just a couple questions.
I'm sorry, I forgot.
That's okay, that's all right.
Can I take just a second? My husband is asking me a question.
Sure.
And I'm deaf in one ear, so I can't listen at both
You're
sides.
what?
I'm deaf in one ear, so
Okay, sure, sorry.
Oh, yes, Your Honor, I'm sorry. There is something that's extremely important that I forgot to mention. It is in there, and that would apply across the board. This particular thing I'll say once, but it applies to all 3. And that is the fact that I cannot, I made a note and still didn't cover it. I can't even apply for the permit in this situation for a fence, because according to the actual land development code here in Ormond Beach, no permit can be issued without a full variance being approved for not having a garage. Our house was built without having a garage. Obviously, that was long before we got there. But the land development code requires each house in Ormond Beach to have a garage and to meet a bunch of other specifications. That is just one example. But I can't go and apply for a permit to have a garage sale or a permit to have a fence without fully meeting all the other land development codes, including that. And so there's been no variance issued at any point along the way. I would have to go and do that. The land development code also requires or states that no permit can be issued without a full development order being issued in addition to that. And so the procedures to get one of those apply. No permit can be issued without an engineer or architect final site plan being approved. No permit can be issued without a recent survey of the lot specifically certified to the city. We're not even talking about the one that we just got a year and a half ago when we purchased our property and it was certified to the mortgage company or whoever it had to be certified to. We're saying that we would have to bear additional costs of roughly, these days, it's at least $750 is what it was costing us to get a certified to the city survey. And no permit can be issued without an application from us that identifies the actual shape and dimensions of the lot, the existing use of the buildings on the lot, the number of families the building is designed to accommodate, the location and number of required off-street parking and off-street loading spaces, landscaped buffer areas, accessory uses of the property, driveway and access standards, impact fees, utility installation fees, sign regulations. That is quite overly burdensome and in some instances literally impossible for us to do just to be able to give them the piece of paper applying for the permit.
Okay. Does the city have a response?
Yes, Your Honor, that's a misread of the LDC. The fact there's no garage, that applies to new construction. You would have to have a garage on a single-family residence. That applies to new construction. And using her example, she would not have to get a variance to get, for example, a garage sale permit. That doesn't make any sense, and I'll just leave it there. But I would ask her a couple questions. When did you when did you purchase this property? Approximately.
Fall of 2021.
Okay. Did you know you needed to get a permit to install a fence on your property?
I knew that we didn't need to have permits because of the interaction we specifically had with the city in July and August and September and October about 924 Rollins Avenue.
No, I'm asking you about this particular property.
Yeah.
Did you know you needed a fence?
I'm answering about this property because if it's not required for 924 Rollins Avenue, then it's not required for 33 Cypress Circle either.
What was there a new fence installation on Rollins?
There was an entire gut job done on that property. Dumpsters kept being pulled up and the sellers were supposed to have pulled the permits, and when we were told days before closing that they never did, they actually then went and prohibited us from getting whatever permits that they should have gotten, and they canceled the permits that we had been able to obtain to that point. And then when they temporarily got possession of the property, as we were litigating this issue and trying to sue them for specific performance, they brought up one dumpster after another to completely tear out and gut the house, and the city refused to do anything about it whatsoever.
Well, you're a lawyer. You didn't think to call the city to find out
We
prior
did.
to elect. Did you call the city to find out if you needed a fence permit for the property that we're here talking about today?
I would not call somebody when an answer was already provided to me in the same year.
On a different property?
Like I said, equal protection applies, so I wouldn't assume we're going to cherry pick and say we're not going to enforce the statutes or the land development code when it would benefit us at 924 Rollins, but we are going to try to enforce some sort of regulations on a different property when it would not benefit us or harm us. So no, I wouldn't think that there would have been something in the books saying that you could do that.
Okay. At some point you did realize the stop work order on the property in regards to the fence?
When our fence was done, yes.
You didn't have any idea that there was a stop work order?
On this, no, because it was never communicated to me by email that day. It was never communicated to me on the phone when we had, I don't know, an hour-long conversation that morning. And they didn't bother knocking on the door and posting it or trying to personally serve me. They didn't send it in the mail, U.S. mail, certified mail, nothing. It was put in the boulevard facing away from, which we later found out when we saw it on video footage.
Okay, you saw it facing away from you, but you didn't go around the front of it to take a look to see what
Like
it
I said, it actually wasn't on the sign when we saw the post. We saw some random stake. It had started storming that day, and by the time that I saw that there was a stake in the yard, there was no sign attached to it, and we didn't find it until later. I'm not sure exactly when at this point, but we didn't find it until much later.
Okay, thank you.
All right, thank you. We'll proceed with case number 22-112246. And the alleged violation has no building permit issued under the code, storage container placed on the property without a permit. Proceed.
My name is Janet Bruce, Neighborhood Improvement Officer for the City of Ormond Beach. The case before you is case number 22-112246. The respondent is Michael Henry and Katherine Henry. Violation address is 33 Cypress Circle, Ormond Beach. Chapter 2, Article 3, Section 250, A9. Metal storage containers being used as sheds installed on the property without obtaining a permit. I would like to submit into evidence a copy of the notice of hearing and $100 citation with proof of good service, copy of the notice of violation with proof of good service, affidavits of regular mail and postings, copy of property appraiser's record, a copy of the land development code that is at issue in this case.
Any objections will be admitted into evidence. Is this your standing objection from the last one?
I'm just making sure that I know exactly what's in it, First Your Honor.
You want to take a look at the, have you got it?
Let me just make sure that excuse me.
Yeah.
I would just have the same objections
A
that,
standing objection, okay.
there is one more photo in this packet that wasn't in, I'm sorry, that's the next, I don't have an objection to that. Other than my previously raised objections, I don't have any further objections to that particular packet because you still have the photo packet that's separate, right?
Okay. So it's submitted as a composite cities exhibit 1.
I'd also like to submit photos which led to the issuance of the notice of violation and the citation, photos of the last status of the property which reflects the current state of the property, the recommendation page, as well as the case file sheet.
Any objection to this being omitted?
Yes, Your Honor, I realize that you've already heard me as far as the fruit of the poisonous tree argument. If I may approach just to point out a specific picture. That should be in the first. So,
These are the ones she's asking to be omitted. Here, is this, that the same thing?
that is not the exact same angle, yes, that showed.
Okay.
shows.
Let me see your picture. Okay, yeah, this is pretty much.
So there's my car. Yeah, I think you can tell that that's my
Yeah.
car right there and then my van right there.
Okay,
It's a slightly different angle, but it's,
okay,
I'm not sure that they're different.
okay. So then it-
Actually, do you mind if I see which other ones might be
Sure,
different?
just go ahead and look.
And we're talking about the shipping containers, right? Maybe, am I looking at the wrong? Where's the other? Okay. I was looking at the wrong packet.
Oh, but your objection was admitted as a
Oh,
composite.
Your Honor, may I state what my objection is about that?
Oh, I thought it was a standard objection that, oh, do you have a, yeah, sure.
In addition to the ones that I have raised before, what is on page 2 of this, it's the bottom, I'm just out of curiosity, on the screen, you have all the pictures that are in this.
Yes.
Can you go to the 4th picture? Okay, so in that picture, you have my van that's on the far right, and what appears to be a glass reflection with some water on it. I guess it had already started raining by the time they put the signs up that day. But that is the windshield. I can't tell the angle of which direction my car was parked, but at any rate, she had gone, what I had mentioned earlier that I didn't have a chance to bring the video evidence, this photo shows, I think the one in the pavers shows it a little bit differently, but this particular photo shows that she had gone in between, or essentially around where my car was, and my car, this is the pavers one? Just for demonstration, I guess to explain the context, could I show you one they haven't introduced yet? This top one shows where my car is parked. So I'm just trying to say how she was getting, and she was on my property going in between the vehicles in order to take these pictures. And so that, I'm saying, I want a warrant.
Okay, can you
Your Honor, may I respond? Yes. That picture is taken still from the sidewalk. I used the zoom on my camera. So I did not walk onto her property. However, in this case, at the beginning of my case, through our trainings, we are permitted to walk up to the front door to take photos of any said violations. However, in this case, I did never walk to her front door. I always maintain myself on the sidewalk. This photo was taken using my Zoom feature on my camera.
City want to respond to any?
No, that's good. Thank you.
Okay, this is omitted as exhibit for the city. Exhibit 2.
further in this.
I can go back from the beginning, Your Honor. The storage containers that were placed on the property are not only not permitted, however, I did use the building permit case on this case due to the fact that she did indicate to me she's using them as a shed. So I did use it as the not obtaining a shed permit case. This shed/storage containers are currently on the property line, not meeting setbacks as well. This is September 2nd. This is September 2nd. October 25th. And February 21st is the most recent photo that shows the property on its current status.
What's your recommendation in this case?
I recommend finding that a violation of the Land Development Code, Chapter 2, Article 3, Section 2-50A9 exists, and that the respondents be ordered to pay the $100 citation as well as the associated case costs, and shall comply by removing the shipping containers from the property by March 27, 2023. The shipping containers are not an approvable accessory structure on the property pursuant to the requirements associated with the Land Development Code, Chapter 2, Article 3, Section 2-50A9. Absent compliance, I recommend a $25 per day fine be imposed beginning on March 28, 2023, and shall continue to accrue until compliance has been achieved. Further, the respondent shall be obligated to contact the City of Ormond Beach Neighborhood Improvement Division to schedule a reinspection of the property to confirm compliance and the date thereof. Absent compliance, I request that the city be granted the authority to enter onto the property on or after April 10, 2023, and have the right to remove the 2 storage containers from the property with all costs thereof to be assessed against the respondents. In addition, should the city remove and dispose of the aforementioned containers, the city shall not be responsible for any damage or loss associated with said removal. And the case cost is $23.56, and this is the breakdown.
Okay.
Now, Ms. Henry, do you have any other responses on this particular case before we go to the third one?
I do, Your Honor. I was trying to find a particular document. The initial document that the city had sent to me, and I'm not sure at this point, it must have been the original thing they sent by certified mail. At any rate, I referred to it in my notice back to them on my response on November 8th. But with the fence and the pavers, it was mentioned that I needed to get a permit or remove the items. With the shipping containers, it says I needed to get a permit, not to remove the items, which I found peculiar that they were different amongst them. And then as I was finishing up my response to the city, I got an email from Janet Bruce saying, I think it was the day before Election Day, so the 6th, maybe November 6th, saying that my shipping containers just simply needed to be removed. She and I talked on the phone shipping containers are not prohibited in the ordinance or the Land Development Code. They're not even mentioned anywhere in there. And when I asked for clarification as to where she thinks that is, all I was given was the generic one that she cited today, and I responded to that in my response to them on November 8th. There's quite a bit of argument in there about how just reading the language of the code itself, it's there's so many ways. I mean, I would take up way too much of your time, and you said you've already reviewed it, but the definition of development code and the definition of structures and utility structures and accessory uses and all that, I laid out.
Which page did you have that on?
It starts, the general discussion of that starts on page 19 of the one that I sent in November.
Mm-hmm. Yeah, I'm looking at it now.
I'm trying to find the specific paragraph. Okay, so the notice that they sent me says that it's in violation, and what they're saying today, 250A9. But Land Development Code Section 250DD1, which is entitled Sheds, Utility Structures, Playhouses, and Gazebos, states that a building permit shall be issued prior to the erection of any accessory structure. However, the Land Development Code defines erected the same as it defines construction or start of. So then you have to look at 1-22. Again, I apologize, but I didn't make these convoluted, they just are. So looking at 1-22, construction or start of is defined where the actual start of construction means the first placement of permanent construction of a building, including a manufactured home, on a site where, and this is a direct quote, permanent construction does not include the installation of accessory buildings such as garages or sheds not occupied as dwelling units or not part of the main buildings. And I don't think there's any denying that we're not occupying these shipping containers as dwelling units, and they're not attached to or a part of our main buildings. And if you look at the Community Planning Act, which governs, that is the state law governing these proceedings and all of the Land Development Code, the term structure is, the Land Development Code refers it to Florida Statute 380.031 Subdivision 19 for looking for what the meaning of structure is in these contexts. It only includes movable structures which can be used for housing, business, commercial, agricultural, or office purposes, which are, the shipping containers are not, they don't fit those qualifications. There's no AC, heat, plumbing. They were purchased as storage containers. They're being used as, and they remain storage containers. So they don't meet the definitions of the state statutes. So they are excluded from what the state law talks about there. We don't have a system where we have to just come and, obtain permission. We have to assume that we have to have permission to do everything on our property, and we have to look for where in the law it says we have permission. That's not the system of government we have here. If the government is trying to prohibit us from doing something, whether it's installing shipping containers or something else, then the government has to have a legitimate purpose for that, and they have to spell that out very clearly. And that I can give you an actual Florida Supreme Court case. It's been precedent for quite a while, and actually cited another case that's been on the books for even longer. But the Florida Supreme Court, yes, Your Honor. The Florida Supreme Court in City of Miami Beach v. Fleetwood Hotel was citing the Libris v. Harper case from 1925 that talks about, in these situations, whether the municipality possesses a specific power to do something, such in these situations, any doubt will be resolved against the city because we have inherent rights as people here to possess property and protect property, acquire property. All of that is a given in our society, and I've cited that as well. But the Supreme Court explained that because of that, anytime you have any kind of doubt whether a certain term is covered or not, then the doubt has to be resolved against the city. And certainly here, for how pervasive the use of shipping containers, I don't know if you're from anywhere else, Your Honor, or if you visited up north, but, you know, we're from Michigan originally. I've also lived in Minnesota, and I can tell you that you really don't see shipping containers except for at like freight yards. Here, it's like, you know, shipping container every 3 properties, it seems, especially when it comes to beachside. There are a ton of shipping containers being used, and I'm assuming after I've now survived 2 hurricanes as a Florida resident, that it's because they hold up well, they don't fall over like sheds. All my neighbors' sheds that were like flying around and being ripped into pieces and being essentially shrapnel throughout the neighborhood during the hurricanes, our shipping containers didn't do that. But at any rate, when it comes to the part of the code that they're citing, it's not, you can't just look at that one to issue a permit. If they're going to issue a permit for something, they have to look at the code that they're citing, and then they have to look at, okay, well, does it meet the definitions, and what are all the other requirements, and what are all the code pieces that relate to that? Well, that's what I did, and I laid it out for them, and they have not at all even alleged where it says in there that a shipping container is not allowable, other than generalities. So to just throw out there that it's just not allowed is not okay. I guess as far as things go, I'm not sure when to ask this. I was actually waiting for the opportunity of when I would be able to ask the city a question, or whether that would be you, perhaps, for clarification. But nowhere, in terms of the pictures that have been demonstrated, nowhere in the law does it say that city personnel is permitted to walk right up to the front door and take pictures as they see fit. They can't go on the property without a warrant, period.
Okay, well now, when we started out, I think I asked if you wanted to ask any questions. We may have stopped it along the way. So of her testimony now, do you want to ask her any questions pertaining to that, or would you refer to the city attorney's office? What do you want to ask them?
Quite honestly, I'm flexible. I don't care who answers it,
Yeah.
but I would like to know, since everything that I've seen says that even a law enforcement officer cannot go on a property for purposes of taking pictures in these situations. Certainly, one who is not deputized in that manner cannot do that.
Okay, so is that a question?
I would like to know where it
I'll
says
let
they
the
can
city-
do that.
City attorney say
Okay, I think we already had a code enforcement officer state that that wasn't the case, so I'm not really sure the relevancy of the question, but anyhow, I will answer it. In Florida, you didn't mention that you had a no trespassing sign on your property. You are allowed to go up to someone's front door, just as the Amazon driver goes to drop off a package. That might be different if you have a no trespassing sign on your property, but I don't believe you have, and I don't believe you've instructed code enforcement not to do that, or if you have, I'm sure they have not come after that. So I disagree with what you were saying, and it's not particularly relevant, but I would answer the legal question.
But where does it say? Because the trespassing statute said that you don't have to put a sign up when it's your permanent residence.
Okay, you know, I'm getting past what I want to hear pertaining to this.
Okay, if I'm not going to get the question answered, that's fine, but that didn't tell me where in the law, because the
Okay.
trespassing statute
Well,
does
you
not.
may have to deal with what you got as far as an answer.
Okay, Your Honor. So I guess my concern with that, I apologize right now. I don't even remember. Am I only supposed to be asking questions, or can I bring up the last point that I have on the?
So you bring up the last point.
Okay. When it comes to the shipping containers and having the permits, et cetera, there are 2 things, and I don't know if the second one is really going to be relevant or not, because I'm not sure what your findings would end up being, but the 2 things that were brought up, at least on the phone, by Janet Bruce were not being able to have a shipping container at all, and even if we could have one, that it has to be at least 7.5 feet back from the property line. So again, depending on what your findings might be, that other portion might be relevant, it might not. And so to that point, I just wanted to specifically point out to you, I know we've talked about it in general, but as far as Shipping containers, sheds, structures. First of all, again, the city's own park on beachside has a storage container. It's actually one of the pods containers, which would be more of the transient in nature types that is covered by the land development code. And those are only supposed to stay on the property for 30 days. That has stayed there since, at least since we've lived here. And it continues to be there as of this date. And there's a picture of that. The city shouldn't be able to, again, cherry pick which ordinances apply to which properties. But also, in talking about the issue of shipping containers being a thing at all, I gave, even in my very first response to them in November, I said, we have just a few streets down, when I went on for a walk, I was able to take a picture of 2 more, that those are actually in the front yard. They're not even in the backyard of the property. They are the same size, shape, and color as the shipping containers that we've had, and they've been there for quite some time. So again, to say, and there's no permits, there's nothing even applied for in the public record for those shipping containers. But when you talk about whether it's actual shipping containers, which I've sent you information on, or the 263 other violations where it comes to a structure, shed, you name it, that is right up to on the property line or within 7.5 feet of the property line, I think 263 other examples within a 1/4 mile radius of my home shows being singled out and an equal protection violation, pretty darn clear, more so than just saying, well, how can you only get me? I wasn't the only one speeding that day. This shows something that's being singled out.
Okay. All right. Now, I have finished with this this second case. Now, you've been sitting there talking quite a bit. Let's take a break. You probably need one, everyone else does.
Sure, Your Honor.
So we'll take a 10-minute break and then we'll go to the third case, okay?
I do have, when we come back, some questions in regards to this, just a
Let's
few.
go ahead and do that, right?
Okay. You have 2 shipping containers on your property right now?
Yes, we do.
And how long have they been on your property?
Since last year.
Approximately, just in the fall of last year or summer last year?
I believe it was March or April.
Okay, so almost a year. Okay, and what are the size of the containers?
If you guys had asked me to bring this information ahead of time, I certainly could have complied a lot easier. Off the top of my head, I'm going to wild guess and say 8 by 20, but I have no idea.
Okay, and do you know what they're made out of? What the materials are?
They are made of what all other shipping containers are made of, but these are first
Steel?
trip containers, so they are not the ones that have all been beaten up and battered by being on the seas for years and years.
Okay, and what are you using them for, or what's your intent to, how you intend to use these containers?
Well, as we're required to have a garage, but after we got into the property, the code was clarified further with us that we weren't actually able to put a garage in anywhere that makes common sense to use the property. Those essentially are helping to keep inside things that my neighbors don't want out and about during a hurricane that can be used as projectiles. Things that, quite frankly, a lot of my other neighbors have on their front porches and have sitting out on a regular basis, or in their sheds that all got decimated and torn to shreds.
So basically storage.
We're certainly not living in them, yes. I'm doing no business in them. I mean, I don't know what else, just
Okay,
to
that's
clarify.
all.
Okay, thank you. We'll take a 10-minute break now. One, I think we have everybody back. All right, the next case is case number 22-11207, parcel 422302060130, Michael Henry and Katherine Henry. The alleged violation at 33 Cypress Circle is no building permit issued in the Land Development Code, Chapter 1, Article 3, pavers installed without obtaining permit. And we'll proceed with the city.
My name is Janet Bruce, neighborhood. Yeah, I'm sorry, Your Honor. The city would, and going back to the previous case, we had, one of our city planners, who's also gonna testify, and we also have some neighbors.
With the other case,
Yes,
did we have, anyone to testify in the first case that I missed, or just the second case?
the second case.
Okay, and,
We're still on.
Oh, okay.
the second case, as to storage containers.
Yes, Your Honor.
Okay.
Yeah.
We're going to get someone who wanted to testify.
I was just going to check the main office to see if anybody was there.
Oh, okay.
She just went
But
around.
Sarah, we're gonna call you.
Right now?
Yep.
Okay.
Are we ready?
Yes, we are.
We're still on, case number 2, which is 22-112246. The city has presented its case, and I've heard arguments from the respondent, and the city has some individuals that they want to testify. Who is that?
Yes, we have, one of our city planners. And if I may, Your Honor, just briefly, just kind of, following the respondent's testified to, you know, we have a fence case and a paper case, and in those cases, we've asked, the respondents to, obtain a permit, you know, for those, because fences and pavers are something that can be approved. It may be modification of height or setback, or you can't, you know, have too much impervious area, those sort of things, but they are subject to approval. Storage containers such as this, cargo containers, are not gonna be subject to approval in a residential neighborhood, and that's why we're gonna call the city planner to explain that.
Okay, you come forward here. And you were, would you be sworn?
Of course. Good morning, my name is Sarah Cushing.
Please raise your right hand. Do you swear that the testimony you are about to give is the truth, the whole truth, and nothing but the truth?
I do. Again, good morning, my name is Sarah Cushing. I'm with the planning department with the City of Ormond Beach. I'm here and available for any questions that you may have.
Sarah, if you could explain, you've looked at the photos of the cargo containers, and could you explain why or why not these would be permitted in the city of Ormond Beach?
Of course.
If someone applied for a permit.
Yes, definitely. So, all of these types of shipping containers, whether they're a Connex container or a temporary pod container, all of those accessory structures are outlined in section 2-50 of the Land Development Code. Specifically, item number X, with outdoor storage. Item number 3 specifically states that personal on-site storage structures shall be limited to situations where a person or business is moving to a new location. This storage unit shall not be placed on a period for over 30 days. So this particular structure that we see in the images above are for temporary purposes only and subject to only be used for moving purposes. If somebody by chance needs longer than that, there would need to be cause to show that it's actually for moving purposes. As we heard earlier, it sounds though as if this is more of a long-term storage, and this would be more of the accessory structure for a shed or a detached garage. Sheds are accessory structures that are outlined in section 2-50N. I'm sorry, that's fences. Section 2-50 D that outlines sheds, as you mentioned, sheds, utility structures, playhouses, and gazebos, more specifically. Sheds are anything that are built according to Florida Building Code standards, and if it's under 150 square feet, it can be 7.5 feet from the rear and side property lines, assuming that there's no platted easements. If by chance the structure is over 150 square feet, then it has to meet the principal setbacks of that particular zoning district. The subject property is located within the R4 zoning district. It is identified as a duplex in this zoning district, and the rear yard setback for an accessory structure over 150 square feet would be 20 feet in the rear and 20 feet on the side. So have had anybody come in to talk about options for sheds, detached garages. The whole purpose of the planning department is to go over these regulations, to answer any questions in depth, look at some type of survey or aerial, and go over what reasonable locations could be on this property. We understand that this particular neighborhood, along with other historical neighborhoods in the community, may not have garages, so having that detached garage for an accessory structure for storage purposes is something that would be encouraged rather than a Connex trailer. Thank you.
Thank you very much.
Any questions?
I certainly do. You mentioned that with, I believe you mentioned accessory structures, that the setback would be 20 feet on a side.
Yes, ma'am. For the particular zoning district that your subject property is located in, it's the R4 zoning district. This information can also be found on the website, but I'd be happy to send it to you. R4 zoning district is a single family cluster and townhouse zoning district, and there's a number of different types of single family options in here. This particular one in Bryan Eleanor is a duplex and subject to the setbacks outlined in the duplex column.
So, do you know where it would say the 20 feet?
In that zoning district, it's section 2-17 of the R4 zoning district outlined in the city's land development code. Under item 9 is where you have your setbacks, and item 9A all the way through 9E outline setbacks of that zoning district. And again, you would be looking at the column for duplex.
So it wouldn't be 20 feet in total, so it could be 8 feet on one side and 12 feet on another side? You're saying it's 20 feet per side setback?
Correct. If it was a single family home, in this particular zoning district, the 8 foot on any one side, a cumulative total of 20 would be applicable, but because this is a duplex, the duplex, again, is 20 on the side and 20 in the rear.
Are you familiar with, you obviously testified that you've seen the pictures. Have you also then looked at the aerial view that was submitted, or just familiar with the government's property records, the property assessor's records that show the aerial view of the property?
I have not specifically looked at the aerials of this particular property, but I'm familiar with the neighborhood. And if you had a survey, I could be able to help provide better guidance and direction.
So does it sound about right to say that these parcels are no bigger than 1/4 of an acre?
Until I see a survey with the measurements, I wouldn't be able to give you that answer.
Okay, so if you did have a property that was no bigger than 1/4 of an acre, where you have, say, 88 feet total frontage, are you saying it would still be physically possible to end up placing any kind of other accessory structure other than dead in the center of the home?
It would be dependent, one, on the size of the accessory structure. So if the accessory structure is over 150 square feet, then it has to meet the principal setback requirements. If it's under 150 square feet, it has to meet the setbacks of the shed accessory structure, which can be 7.5 feet to the side and 7.5 feet to the rear. Assuming that there's no drainage or utility easements within that, no accessory structures outside of a fence can be placed within these particular type of easements. But until I know exactly the size and the location and have a survey, I wouldn't really be able to tell you reasonably what would be permissible or what would be the most accurate or anything of that standard.
So what would you say is supposed to be the procedure if you have people that call on a property? I don't know if you're familiar with how hot the market was, at least in 2021. Property came on that day, you had to put an offer in that day. So if you have a realtor or a prospective buyer on a property, a specific property, reaching out and saying, hey, 33 Cypress Circle, can you put a garage here? What if it's, quite frankly, I don't even know who it would be directed to at that point, but if you have somebody from the city replying back and saying, certainly you could do that, it just has to be 25 feet back from the front property lines, etc. There's no offer of looking at the survey, there's no offer of going into any further detail. In fact, it takes several emails back and forth just to get a copy of what section of the code would even apply. You mentioned earlier that it's an offer, the purpose, one of the purposes of your office or maybe your position is to be able to sit down with residents and explain some of those things. So how is it that that's available, but yet the city doesn't communicate that? How would a resident know that other than reaching out and saying, hey, this is specifically what we'd like to do at this specific property, how can we make it happen?
Of course, so those are very good questions I'm happy to help give guidance on. So everybody has its own zoning district, every home does. And it's really up to the due diligence of the property owner to reach out. I can't come up to you and say, hey, you have to do X, Y, or Z. But we get emails all the time, we get phone calls all the time, and we have people come in person all the time. That's what our office deals with, is handling these inquiries and providing them with the necessary tools that they need to make the decision that's best for them and their property, so that they can move forward with the appropriate permits if necessary. So if somebody were to call and say, hey, 33 Cypress Circle, I have, the interest in wanting to put this particular shed here, I would do exactly what you just stated. I would get their email contact information, so that way I can send them an email with the regulations that reference the particular question in play, such as sheds. Oftentimes I attach the detached garage standards, because once you go over an accessory structure over 150 square feet, that automatically goes into the definition of detached garage. So I kind of explain that in that written email. When they provide the address, then that can help me provide the zoning district regulation. And then I usually typically give them guidance of how to navigate the city's website as well. So that way, if you're looking at this property temporarily, or you're looking at another property, you have the tools necessary to do that research on your own if it's after hours and you're looking for an immediate response.
That sounds great. So if a realtor such as ours, when we purchased this property, were to reach out and email the city, and quite frankly, I don't remember who it would have been, but let's say it went to somebody else just in the general, city office, whatever city hall, right? Are they supposed to funnel those types of questions to you or your department in order to give the correct information?
Yes, ma'am. It depends on what email that you're sending it to. If you're sending it to just the general city email, whether that's upstairs in our city clerk's office, then they would definitely forward it to the appropriate department. For instance, our permit office, our permit technicians have their own individual emails, but we also have our general email inbox with BP Online. And all of the general permit questions go there, and then the permit technicians will review those and forward them to the appropriate departments. Because, for instance, somebody could be sending a general email asking about setbacks for a property to BP Online. They would send that to the planning department rather than the building department. But if somebody's asking questions about Florida building code and safety requirements, wind load speeds and the like, they wouldn't forward that to me, they would forward that to our building department for clarification for that particular.
So is there some sort of procedure in place then when your department is not given, I can't imagine I was not given the information that you mentioned. I was not given an offer to look at a survey, to go over anything. I was actually given information that was incorrect. One of the things was they specifically said has to be the 8 and 12. If you have 8 feet from the property line, that's fine as long as you have 12, specifically for the property that we have with the zoning that exists today. And so if you're telling me now that the information we were given in email, which of course I don't have ready access to right now because I didn't know it would come up, but if you're telling me that that is incorrect and that it has to be 20 on each side, with a property that's only 80 feet wide, that's basically putting it in the middle of a property, is there some sort of catch-all procedure that would help people be able to know that they're getting the right information, or be able to have somebody give it a more thorough, how would somebody in my position who went through a realtor, who contacted the city, and got an answer, but apparently got the wrong one, what would there be for a remedy to make sure that we're getting the right information?
I understand your question. I would encourage you as the property owner to do your due diligence above and beyond what the realtor's due diligence is. Because while they're gonna be reaching out and asking these questions for you, how they interpret the information that's given to them is one thing, you know.
And I appreciate that. There was no interpretation. She forwarded on the email to me. In fact, I think I was just copied, so I think I got directly the response from the city. So there was no interpretation from the realtor whatsoever. I'm specifically talking about information that came directly from the city. So is there really not any kind of mechanism or procedure to make sure that either the correct people or the correct information is being provided then when residents do due diligence and reach out before even putting an offer in on a property to make sure that they can do some of those things?
Again, it's the same thing, reaching out to staff and providing for that clarification. If you feel that the direction and clarification that you got from one staff member may or may not be accurate, then you can reach out to others. But it's the same information that you're gonna get from one staff member to the next. We are a very small group of staff members that works closely with our land development code and the zoning districts, and understanding this difference of setbacks depending on the type of structure within that zoning district itself really helps give that particular direction to the inquirer.
So,
okay, this is getting to the point where it's not assisting me in trying to make my decision. So if you'll line up your questions of this witness.
Yep. So you testified about that 250, section 250 of the LDC categorizes what I have as temporary only, and then it can only be used for moving. What in there, where in the code does it say anything about that those can only be viewed as or defined as temporary and then used only for moving?
So 2-50 is for accessory structures as a whole, all of the different types of accessory structures. 2-50X is for outdoor storages, specifically item number 3, so 2-50X3 talks about on-site storage structures, which this would fall under that category.
Is that defined anywhere in the code?
So you can go under temporary structures, you can go under our definitions, I believe it's 1-22, which has those different definitions in there. But those are that's typically the standard protocol of using these Connex trailers or pods as moving purposes only. If you're talking about long-term storage, then we would be going into an accessory structure like a shed, if it's 150 square feet or under.
I was just asking about what the definition was, because I guess my confusion is that, hopefully you can clarify this. 250 DD3 that you have mentioned that talks about sheds and utility structures.
I was quoting 250X3.
Just now, but earlier you talked about 250 DD that is specifically about sheds.
Yes, ma'am.
You said it requires that any structure or shed over 150 square feet shall be considered a garage and must meet the principal building setbacks, which you mentioned earlier.
Yes.
However, you also just recently mentioned LDC section 1-22 to look at the definitions, and 1-22 doesn't actually talk about the temporary or connex or any of the things that you said are in there. They're nowhere in there, but what is in there is it talks about utility structures, but that they are only defined as accessory structures that do not exceed 150 square feet. So this being larger than 150 square feet, it's not covered as a utility structure under that part of the code. So
So if that's the case and it's exceeding 150 square feet, it automatically gets defined as a detached garage and has to abide by the detached garage accessory structure standards.
and where does it say that in there?
So specifically 2-50 double D, 3A, for the purposes of this section, any utility structure or shed over 150 square feet shall be considered a garage.
Okay, where are you reading from on that specific?
2-50 double D,
Okay.
and
Right.
it's for the area requirements. And then you go into a definition of a garage, and specifically a detached garage, and there's certain standards required for detached garages, one of which are meeting the principal structure setbacks.
Okay, thank you for your testimony. We're gonna move on.
Okay, thank you, sir.
I'm sorry, may I ask just a couple
Yes.
questions, I'll be quick. Does the Florida Building Code address use of cargo shipping containers for residential purpose?
So that's a good question. So our office deals with the planning and the land development code side of the regulations. Florida Building Code standards are above and beyond. It's what the state requires all of the structures to meet certain requirements for safety. The building department can answer those specific questions, but it's my understanding from previous conversations with some of their staff that these particular structures aren't regulated under Florida Building Code standards and therefore wouldn't be able to pass a permit with their department.
Okay, and one last question. The respondent mentioned whether or not there was a mechanism for a homeowner to know whether or not there would be, a structure would be permitted on the property. Wouldn't a mechanism be the application of, one of them being an application for a permit, so you can review that before they expend the time and money to bring something onto the property?
That's correct, yes. So there's a number of different submittal requirements when a permit comes in, one of which is a site plan that shows the proposed location of the structure, the size of the structure, and the setbacks to the applicable yards. And that's what I would review in the planning department for LDC review. And then the building department would review it for Florida Building Code safety requirements, and typically, like shed manufacturing specs that you purchase, if you buy a prefabricated shed, it will have those like specifications that show how it meets the Florida Building Code requirements.
Your Honor, I do have a follow-up question because she specifically mentioned garage. So earlier, I'm not sure if you were in the room, I didn't see, but earlier, the city attorney argued that my interpretation of the land development code regarding needing properties, residential properties in Ormond Beach needing a garage, that somehow does not apply to me. Do you happen to know, first of all, would you agree with the fact that the land development code requires properties to have a garage?
Yes, so as our attorney mentioned, new builds that are required to have a garage, whether it's an attached garage, a detached garage, or a carport, some form of a garage with new builds. This particular neighborhood was built prior to the current land development code standards, so it could be exempt from that. We're not going to cite you for not having a garage, but if you were trying to build one going forward or do any form of expansion, we would talk about those processes and procedures at that point in time.
Okay.
If you're talking about,
Just
just one moment.
Okay.
And so if you're talking about a shed that's over 150 square feet, even if you're not using it as a garage, it's still defined as a detached garage because it's over 150 square feet. So you can have a 200 square foot shed in your backyard, and that is okay, it's subject to meeting the specific setbacks.
Okay, so you're saying that you guys, it's not so much that the land development code, and I'm asking what I understand and asking you to clarify. You're saying that it's not that the land development code doesn't require my property or my neighboring properties to have a garage. What you're saying is perhaps in a matter of fairness or something, that you guys aren't gonna walk around and, knock on each door and say, hey, your house that was built in 1949 doesn't have a garage, and even though you're not trying to do anything to your property, we're gonna enforce this on you and make you build a garage. Is that what I'm hearing you say, is that it is applicable, but you're choosing not to unless the homeowner does something else to their property?
Well, not necessarily something that you do to your property. If you're trying to expand the footprint of your house or something like that, then sometimes that will trigger certain things. Or say you had a garage already existing and you're trying to enclose it for living spaces, we wouldn't be able to permit that enclosure of that garage as living space until an alternative is provided. So I think that's maybe we're flipping the script a little bit, whereas you don't have a detached garage, you don't have an attached garage. We're not gonna hold you accountable for that. But if you had one and you're trying to enclose it, then you would need to provide an alternative going forward.
Well, my question is as to what's actually in the code. So are you saying it's in the code that I have to have a garage and you guys are just not enforcing that part unless certain things are done on my side? Or are you saying the code does not require my property to have a garage? And that's what I'm trying to figure out. What are you saying that the code says?
I may be defer to legal for clarification and direction on that.
The code does not require you to put a garage.
Do you know where it says that? No, not put a garage. The code requires my property to have a garage, and that sets off the trigger for all these other things before I can even apply for a permit. So can you please clarify perhaps where in the
I can do that at another time, it's really a separate issue.
It's not, if I can't apply for a permit, then
You can
that's
apply for a
exactly
permit.
the.
I don't think anyone has denied you.
Okay, this is getting where it's not helping me very much. Thank you for your testimony. Your excuse at this time. Did you say there are other?
There's one neighbor witness.
Okay, who is that? Come forward, please. Say your name, please.
Joan Conway?
Were you sworn to be at the beginning when
Yes,
everyone else
yes.
was? Okay, where do you live?
I live at 9A Bayberry Court. It's directly behind their property.
Did you want to ask her questions?
No, I just let her speak to whatever she
Okay,
wants to speak
what-
to.
I brought plenty of pictures that I didn't have to go onto their property to obtain. And first and foremost, when I made the complaint, I understand that they needed my name and number to make the complaint.
Well, let me just back up. You
Sure.
made a complaint? See,
I'm the one that made the complaint
Oh,
against them,
okay.
correct. From a neighbor I heard a few days later, she was over taking pictures of our property, which is fine. Had a couple of run-ins with both of them. And the last run-in, I was told by Mrs. Henry that she knew it was me that made the complaint, and wait till I wait and see what's in store for me. I don't appreciate
Just talk
threats.
to me, don't.
Okay, I don't appreciate threats, because I went the legal way of reporting them, and was threatened by her. My daughter was there during this, but she's working and couldn't attend today. This has been going on since they bought the house. The fence is atrocious. Elena Village is a small neighborhood with cottages, is which they were built for. And the fence it's an eyesore. It brings down the 5 properties around it, their value. We now have a, light pollution, because they have lights on all over the house that go directly into our bedrooms in the back, sometimes working till after midnight.
Your Honor, I would object to the line of testimony that has nothing to do with the case that's called.
In a way, I'm gonna sustain the objection, for you to come and say that you were the one who made the initial complaint. That's fine for me to know. Usually, I know that now, but that other things probably doesn't help me in any way. Sustain.
She knows that these things aren't permitted, they're putting up a pergola now, that's not permitted, I'm sure. It's one thing after another.
Your Honor, I'm gonna object because the only thing she's offering is a bunch of baseless, backless hearsay that has nothing to do with the shipping containers at this point.
I'm probably not gonna go forward with that testimony, so I would sustain that objection.
So, all the complaints I have are relevant or irrelevant?
Your complaints are relevant, but I know what neighbors say when they come, but I don't need to go into details about it. It doesn't really help me in making my
No, and I understand that, you know, this is a neighborhood of renters. If this was happening on John Anderson, those would have already been removed. There's just no doubt in my mind, because they're all homeowners. This is a neighborhood of renters that are not gonna stand up. They have no, they're not gonna gain or.
I object because if, I have the right to be able to respond. She's talking now about a litany of other things that are baseless.
I
that
don't
I
want to
respond
get into that, so thank you for your testimony.
Thank you.
Okay. No, I'm not
I
gonna
think she
see
had some
cross
photos, I haven't seen the photos.
Yes,
but
I have a bunch of
she
photos,
was-
from the lights peering into our
If you want to
bedrooms.
admit the photos into evidence,
Your Honor.
and then you object to them.
I do, because she says that
Honestly,
she,
I don't know that I'm even gonna admit the photos into evidence.
I agree that that's my shipping container right there, so I don't see what else would be relevant.
All right, thanks.
Thank you, Your Honor.
Yeah. Do you have another neighbor or someone?
I don't think so.
Okay, all right, I'm ready to go to the third case. As the trier of fact, I can make a determination that I've heard all that I need to hear on a particular case. So that's what's gonna happen now, and I'm ready to go with, the third one.
Your Honor, just for clarification purposes, for what was put out there, I just want to clarify that with that testimony, I didn't necessarily have a chance to question her myself, but what I do want to say,
Well, it's because I stopped the testimony.
well, I understand that, but in her continuing to say things, I just want to say that the things that she was putting out there as facts, supposedly us threatening her and all these other things, us ruining the aesthetic value of the neighborhood, everything else like that, it's not accurate, and it shouldn't have been something to be brought up. It's something that we certainly could have refuted with evidence and testimony ourselves. I just wanted to
Okay,
put that on
well, I made
record.
my decision on that.
Yes, thank you, Your Honor.
The third one is, and it is case number 22-112247. The alleged violation is no building permit issued as stated in the Land Development Code for pavers. Pavers installed without obtaining a permit. You can proceed.
My name is Janet Bruce, Neighborhood Improvement Officer for the City of Ormond Beach. The case before you is case number
Speak in the microphone.
22-112247. The respondent is Michael Henry and Katherine Henry. The violation address is 33 Cypress Circle. This is a violation of the Land Development Code, Chapter 1, Article 2, Section 1 through 14, 6A1, pavers installed without obtaining a permit. I would like to submit into evidence a copy of the notice of hearing and a $100 citation with proof of good service, copy of the notice of violation with proof of good service, affidavits for regular mail and posting, copy of property appraiser's record, and a copy of the Land Development Code that is at issue in this case.
Any objection? Your standard objection that you made earlier?
Yes, there's one additional thing, Your Honor, that I didn't catch if it was in the other ones, but it's in this packet. And just when it comes to, as far as posting the notice, the way that it was said is that it was posting of lawful posting of notice, there's proof of that. And I would just specifically ask Your Honor to refer to my detailed summary that indicates how this was not a lawful posting of how they did that. I don't know if I raised that before.
You did before, and I recall it. It's submitted as a city exhibit, as a process.
Your Honor, I'm sorry, are you numbering these? Did you say this is 5?
That's one, isn't it?
Oh, because they're separate, I'm sorry.
I'd also like to submit into evidence copies of photos which led to the issuance of the notice of violation and the citation, photo of the last status of the property which reflects the current state of the property, the recommendation as well as the case file sheet.
Okay, take a look.
Just kind of look at my comparison. sure that we're continuing my objection based on.
The record should be noted on that.
Thank you, Your Honor.
These are photos that did begin on September 1st, 2022. It shows the pavers that are piled up as well as in the process of being laid down. I did speak with the property owner on September 2nd, 2022 and advised her that all of the work would need to cease to get a permit. I did also put on the stop work order the issue with the pavers that need a permit to proceed further with their construction.
Do you have a recommendation?
Yes, sir. This is October 25th, 2022.
No, the papers are all down now.
Now they're all down, yes, sir.
They're all down.
Yes, this is February 21st, 2023. The pavers are completely done. They installed 2 driveways and whatever they did in the backyard.
If a permit had been obtained for these papers that are down, do you have any comment on whether they would have been allowable?
If they had received a permit, I'm not sure what planning and zoning would have stated. However, the setbacks are probably not being met right now. The pavers are going to the property line. So they most likely could get a permit, however, they would have to do everything that the inspector tells them needs to be done, whether some of it needs to be removed to meet setbacks, whether they need to see what's underneath the pavers to determine if it's been built correctly.
All right, do you have a recommendation?
I recommend finding that a violation of the Land Development Code, Chapter 1, Article 2, Section 1-14-6A1 exists, and that the respondents be ordered to pay the $100 citation as well as the associated case costs and shall comply with the code by March 27, 2023. Compliance shall be achieved by obtaining an approved permit for the pavers and meet all setbacks required for the pavers. Absent compliance, I recommend a $25 per day fine be imposed beginning on March 28, 2023 and shall continue to accrue until compliance has been achieved. Further, the respondents shall be obligated to contact the City of Ormond Beach Neighborhood Improvement Division to schedule a reinspection of the property to confirm compliance and date thereof. Case cost is $23.56.
Good. Okay, your turn to argue on this particular case about the papers.
Yes, Your Honor, I actually have, I'd like to start in the form of question to
Okay.
Janet Bruce about this.
To the inspector.
Whatever your title, what's your title?
It's fine.
Oh, okay, then yes, you. I apologize, I didn't know the title. I'm going to reference, I believe it's on page 2 of the Exhibit 2, specifically for this case. Easiest to note by the picture I'm talking about specifically has the hurricane debris from palm trees and things like that sitting in the front. So that's the picture I'm talking about. It's at the bottom of page 2. And I'm not sure.
Yes. Into it, this one?
Yes.
Right.
So the, I'm not sure if you could tell on your screen any better. My black and white copy that I was handed doesn't really show, but so my question is about, and you've been there, so you obviously know better than what the picture would show, but the driveway that was originally paved is essentially the pavers have like an L shape around that driveway. Would you agree?
Yes.
Okay. And so the, what you're saying is, I wish that was a little bit shorter to the ground so I can point, but the.
We have a pointer, a laser pointer.
Do you? Oh, fantastic. Because I'm not that tall.
6 foot
It's-
high.
The right button.
Thank you. At either one? Does it have to be pointed at
It
once?
doesn't.
Oh, it's not tied to the device. Okay, so, let's see if I
Turn it around.
Turn it around.
Turn it around.
Yeah.
Okay, so can you guys see where I'm pointing? Just wanna make sure I'm doing this okay. There's a line right here, and so right here, I'm outlining the side. Were you able to see that, Your Honor, that, that's the portion I'm talking about? Or do you need me to further explain that?
That's it.
Okay. So, my understanding from what you just said, when he asked you about the setbacks, is that you were saying from this line over to the property line, that there has to be 7.5 feet of, where there's nothing, I guess. Is that what you, is that a correct
Janet,
statement?
you might wanna refer to Sarah. for
Yes,
the
that's,
planning questions.
that's a question for Sarah.
Good afternoon, Sarah Cushing with the
Okay,
planning
make
department.
your answers short.
Okay. So with driveways, those are a different accessory structure that are subject to different setbacks. At the property line, the driveway has to be 3 feet back from that side property line. So if the leading edge of that right now is on the property line, it would have to come in 3 feet in order to comply with the land development code.
And where does it say 3 feet? I've always been told by them it was 7.5.
Well, this section is section 3-25 in our driveway and access standards. Specifically, item C, driveway standards number 1. Thank you.
Your Honor, I just need a moment. That's the first time I've heard of that one. I don't know if this would be a question for either one of them. It doesn't matter to me, but based on the documentation I've already submitted showing that I would be held, at least by somebody in the city, to a 7.5 feet setback. My question is about clarifying that when pavers or any kind of concrete is poured or anything that's to enlarge a driveway, whether that has to be then, my understanding is that you cannot build it this way going towards the center of the property, that you can only place those going away from the house and toward the side property line based on the land development code. So again, I'm not sure which one of them would be,
Okay, what's the question?
if that's correct,
Okay.
that you have
Yeah,
to build it.
Can you answer that question?
Of course. So you can definitely build to the left. You really would be more encouraged to build towards the left-hand side of the property, but you have to stop at that 3-foot setback.
So is it correct though in saying that if I tried to put pavers to park right here, that is prohibited under the land development code?
It really depends on the scope of the work, and if we were to look at that together, I would be able to provide some more guidance.
Sure, I think these would be great questions during a permit process.
Your Honor, I'm just gonna tell you that it's actually prohibited from building towards the center of the property. And you have to go out, and it actually does say in there 7.5 feet, but then since it goes to the impossibility. I have to lay pavers that go towards the side property line, but then I cannot lay pavers supposedly that are within 7.5 feet of the property line. And it creates an impossibility to have any kind of extension of parking, and yet I can't park on grass. There's a land development code in the same provisions about parking that says you cannot park on grass or dirt or stone. And so, like the city attorney's office that has dirt and grass and stone and mulch as their parking area, that's a violation of the land development code. So no matter how I do things, my point is that it's an impossibility to meet all of these and be able to reasonably use my property. The pavers are not encroaching upon the other property. It's not changing the drainage or runoff. Other than we worked with the neighbor over there where it shows right here that there's a little bit of sand. That's because his property had a little bit of a dip right there before, and then certainly was exacerbated by the hurricanes. So, when I talked to him one day, when he was out repairing some hurricane damage, on the south end fascia of the property he owns right there, I was able to, I asked him if he wanted me to fill that in with a little bit of extra dirt that we had, to which he indicated yes. So at any rate, other than that, making it better,
I'm sorry, I was talking to my clerk a minute.
okay, sorry, I didn't catch that if I interrupted you. Other than making it better, this little tiny patch where we, asked him if he wanted us to help him out with that, we did not, there's no negative impact. We're not changing, putting more drainage onto neighboring properties, we're not, doing anything, other than making sure we have less transfers, since we can't grow grass here without significant irrigation, which is another thing that's protected by, Florida statutes. We have, overall with all of these, we have, wind mitigation and flood mitigation, methods being used, and those are specifically protected by Florida statutes, and I believe I might have a case. I didn't know you'd be wanting cases when I had statutes, but
Sure.
I believe I might have a case if you wanted me to double check that case speaks to the point that I just made about
Okay.
when you have a Florida statute like that that's specifically calling for those kinds of measures to be made on private property. You want me to look to see if that is your order?
Sure.
I think I have it, I just wanna make sure that I'm not misleading you, Your Honor. Okay, this particular one I brought with me, like I said, I wasn't prepared knowing that you would want cases, at an informal hearing. But this particular one is, actually City of Ormond Beach, versus, Del Marco, I think how it'd be referred to, short citation. It was in the 5th District Court of Appeals from 1983 and still serves as good case precedent to date. And it's talking about a different statute. This is in terms of constructing or maintaining renewable energy sources, but it's saying that the city cannot restrict or prohibit construction or maintenance of a renewable energy source. And I can continue there, but my analogy would be, Your Honor, when the state has made it perfectly clear that they want certain things being done to essentially benefit everyone, such as encouraging sustainable energy use sources, encouraging wind and flood mitigation when we obviously live in an area where hurricanes happen and things of that nature. The state, which I have laid out very specifically, and can go into more specifics verbally if you'd like, but they've made it very clear that no municipality, there's even a statute I cited specifically to that, no municipality can regulate or get in the way of, stop somebody from employing flood mitigation techniques or wind mitigation techniques, from stopping the use of installing things like pavers or rocks instead of having to turn to extensive irrigation in order to simply grow grass, which is what the areas that we're talking about. You can see from the rest of my front yard, it just doesn't grow grass. It's all it is weeds. The only green that you see there is actually just a piece of turf that a neighbor had. And I'm using it to stop the weeds from growing right now until we figure out what else we can do. But that would be my concern. This is the only copy I brought with me. If you wanted me to present this to you, I can.
Let me glance at it right now. Then I'll give it back to you.
Did you you want me to highlight the holding portion? Because I can do that.
No, let me just, from what you said. Okay, I'll give it back to you. Okay, we're going to need to wind up here. Do you have any response to our arguments in this third case?
On that particular case citation, no, Your Honor.
Yeah,
I just would say that it has absolutely no.
Anything else?
Yes, Your Honor, I just wanted to, sort
Do
of.
a summary for me.
Yes, Your Honor.
You've already made the recommendations.
May I speak to counsel?
Yeah.
Sorry. I do, Your Honor, I'm assuming you want me to wait.
Okay, I need you to, you have not made your recommendations on this third case, so I need you to do that at this time.
I recommend finding that a violation of the Land Development Code, Chapter 1, Article 2, Section 1 through 14, 6A1 exists, and that the respondents be ordered to pay the $100 citation as well as the associated case costs and comply with the code by March 27, 2023. Compliance shall be achieved by obtaining an approved permit for the pavers and pass a final inspection, or to remove the pavers from the property. Absent compliance, I recommend a $25 per day fine be imposed beginning on March 28, 2023, and shall continue to accrue until compliance has been achieved. Further, the respondent shall be obligated to contact the City of Ormond Beach Neighborhood Improvement Division to schedule a reinspection of the property to confirm compliance and date thereof. Absent compliance, I request that the city be granted the authority to enter onto the property on or after April 10, 2023, and have the right to remove the unpermitted pavers from the property with all costs thereof to be assessed against the respondent. In addition, should the city remove and dispose the aforementioned pavers, the city shall not be responsible for any damage or loss associated with said removal.
You did not go to the second page. You look at the
It's not,
second page.
it's not on this one, but it is in your packet, Your Honor.
It is in your pack, my pack?
Yes. We have a second.
Okay. All right, thank you. Ms. Henry, we're going to sum up, and I'm gonna let you have the last word. And then I'll let the city respond to it, and Judge, we will finish with the hearing today, and and I will be, asking all of you to leave, and I will sit here with my clerk, and then I'll make my decisions on the case, and then call you back in after about 10 minutes. So, what else would you like to tell me?
Yes, Your Honor. What I want to point out, some things that I alluded to before, but you'd asked me for some more examples. So, in looking at the totality of all three of these, our state constitution, to which everyone here has sworn an oath to uphold and defend, we have Article 1, Section 23, the right of privacy, that we have the right to be free and let alone from government intrusion into our personal lives. Specifically, you asked about a case. The application of a general zoning law to a particular property affects a taking if the ordinance does not substantially advance legitimate state interests, and not once have they talked about any legitimate state interests that are being furthered, let alone substantially, by trying to have my shipping containers removed and removing or changing out my fence and at least tearing up my pavers to see if they were done correctly, any of those situations. Several state laws specifically protect a homeowner's property rights against this very kind of overregulation. Just some examples would be Florida Statutes 187.101, 163.3194 subdivision 4, Florida Statute 70.001. If you look at 163.31776I, it requires local governments to consider constitutionally protected property rights in local decision-making, including this very proceeding. This is the kind of proceeding where we have to remember, no matter the specifics, and not get lost in all the details of setbacks or things of that nature, that beyond it all, or underlying it all, is that we have constitutionally protected property rights that are also statutorily protected property rights. Florida Statute 163.3161 requires that ordinances and regulations be implemented and applied specifically with sensitivity for private property rights and not be unduly restrictive. And property owners must be free from actions by others that would harm their property or would otherwise constitute an inordinate burden on property rights. And Your Honor, what I had tried to make exceedingly clear in my printed versions as well as in questioning and statements today to you was that it is an inordinate burden to try to do these things, where I'm required to have certain parking areas to be a certain material. It can't be grass, it can't be this, it can't be that, but it has to be built out away from the center line of the home, but it can't be within a certain amount of feet from the property line. It's physically impossible to do a lot of the things that they're saying to do. Even to have, we're legally required under the Land Development Code, there is no exception or grandfathering in for older properties. As we heard in the clarifications, it's just more of in the interest of justice, they decide not to go after people who don't have garages, but it's currently written that you have to have a garage, and in order to have, apply for a permit to have a garage sale, to put up a fence, to do anything, you have to have a full variance approval, you have to meet all these other specifics in order to even apply for a permit. And in the end, we had the main argument that I heard from the city attorney today was that, oh, these are great questions, these are things that would be good and fine to do at some other proceeding, but underlying all of this, I am guaranteed a fundamental right of due process, and any kind of confusion or unclarity on any of these points, the Supreme Court has clearly stated for 100 years now, has to be resolved against the city, not against the private property owner who is causing no harm to anyone around her. If somebody doesn't like the look of something on my property, that's not harm. That's their own personal opinion. So, Your Honor, I would ask that you also keep in mind that if you look at the 11 violations that I had prepared to you, demonstrated to you of extensive remodeling and repairs that were done just in the sample neighborhood that I showed you. 6 were specific fences, to fences being built. 1 was about parking, pavers and parking areas. 5 were about sheds or shipping container type of situations. All of those were specifically recently done and in my small little neighborhood, and they were done all without permits. And I also submitted evidence to you that the city knew at least about some of them, specifically with the fence and the stone being put where law enforcement is currently parking on a regular basis, and permits for other things have been issued, so the city has been out there. But 457 examples just in my tiny little area, a quarter mile from my house, where there's other paver violations and requirements not being enforced. 266 other examples for shipping containers, sheds, structure requirements. There's 3 different areas where there's actually shipping containers that have left to be there for far more than 30 days and have no problem, both in residential and commercial areas. Fence land development code requirements are not being enforced at least 63 other properties just within a quarter mile from my house. And the fact that government officials are getting a free pass even just within my small little sampling. Ormond Beach Police Department officers, Volusia County Sheriff's deputies, Ormond Beach City employees, the City Attorney's office, Volusia County Council and former Ormond Beach Commissioner residences, Florida State law enforcement personnel, you name it. There's examples of these very things that are supposedly violations that are not being enforced. And it's one thing to say, oh, well, you know, I was speeding and you know, I got pulled out and I was the only one that was speeding, versus to show you that there are just of these types of violations, just from what I can see, 810 within a quarter mile radius. And if you extrapolate that out to the square footage within the City of Ormond Beach, that means there's over 115,000 similar supposed violations that the city is doing nothing about. You take a look at that versus how they did not follow the law, even on simple things of how to serve me for the hearing for today, or not following the law on 70.45, or a host of other things that I meticulously detailed in the submission to you. It shows that this has been personal for quite some time. I don't know why. I don't know why they've made it personal, but they have. And that kind of selective enforcement has and always will be unconstitutional, and it's illegal. Not to mention the impossibility of being able to even ask for a permit in these situations because of the things I mentioned earlier. So, Your Honor, I'm just asking you to follow the Constitution, to follow state law, and even the definitions of the very land development code that indicate clearly that my fence is not covered in the statutes or the land development portions they're saying it is. My shipping containers are not covered in the codes that they were generally referencing, and nor are my pavers supposed to be removed given the actual language of the code. So with that, Your Honor, that's all I would ask you to do today.
Yes, Your Honor, all 3 of these cases come down simply to failure to obtain a permit. We spent several hours here this morning, all of which could have been avoided, and a lot of time and expense on behalf of respondents had they gone through the simple process of sitting down with one of our planning, one of our city planners to go through these things, and can save a lot of time and money. The respondents talked a lot about their rights and their rights to do with what they want on the property, but I think she said herself that regardless of other people's rights around her and how they think it may look, that doesn't matter. That's not a concern, but I suspect one of the reasons why she probably moved to Ormond Beach is because of the way it appears in the nice community that we try to protect. I do want to mention the recommendations, the orders. 2 of the orders ask her to go ahead and get a permit for the pavers and the fence. Doesn't mean she might not have to make some modifications to those if they don't meet the setbacks or height requirements. requirements or materials. We don't know that because we don't have the information. You know, part of the requirement is to do that. We have not asked that, and that's the typo on the shipping containers. We mentioned twice, chapter 2, article 3, section 2-5, and it really, the second one should be deleted. It's just,
Is that in the recommendation?
it's in the, yeah, it's in the recommendation.
Can we go back to it? Any way I could look at this?
But the reason why, Your Honor, we're not ordering her to get, to go through the permit process is she's certainly welcome to do that. If she wants to try to get a permit for those shipping containers, she can, make application and she can pay the permit fee. But we don't like to order that, Your Honor, because shipping containers, cargo shipping containers are not gonna be permitted in this residential zones. Therefore, we didn't want to order her to do that.
Okay, well, where do you say that?
Okay,
I'm
see-
looking at it now.
Right, where up above, where you say chapter 2, article 3, section 2-50A9, that's failure to obtain a permit, and we repeat that citation down below, and we just should strike that second, citation reference. It's the same reference.
Still, I'm looking, okay, all right, okay.
And that's all. Thank you.
Okay, thank you, folks. I'm gonna ask, everyone to take a break, and if you'll go ahead and go on out, and then I'll work on my order right now with, my clerk. When we're ready, I'll give you, all that. I find that the respondent's argument that constitutional rights to her property have been violated under the state of Florida and U.S. Constitution are without merit. I find that the respondent's argument that the City of Ormond Beach has not issued adjoining properties or properties in the area citations, therefore this should not be issued a citation to her is without merit. I find that the arguments that the application of a general zoning law as to particular property does not substantially advance legitimate state state interest is without merit. Therefore, as to case number 1, I find that there is a violation of Land Development Code, Chapter 2, Article 3, Section 2.50N1A, and that the respondent is ordered to pay the $100 citation as well as any associated costs, which are $23.50, and shall comply with the code by comply with the order by March 27, 2023. Compliance can be achieved by obtaining an approved fence permit and pass final inspection, or remove the fence from the property. Absence compliance, I order a $25 a day fine be imposed beginning on March 28, 2023, and it shall continue until compliance has been achieved. Further, the respondent shall be obligated to contact the City of Ormond Beach Neighborhood Improvement Division and schedule a reinspection of the property to confirm compliance and the date. I grant the city to enter onto the property on or after April the 10th, 2023, and have the right to remove the unpermitted fence from the property, with all costs thereof to be assessed against the respondent. In addition, should the city remove and dispose of the aforementioned fence, the city shall not be responsible for any damage or loss associated with it. As to case number 2, storage, I find there is a violation of Land Development Code, Chapter 2, Article 3, Section 25089, and the respondent be ordered to pay the $100 citation as well as the associated cost, and shall comply by removing the shipping containers from the property by March the 27th, 2023. I find that shipping containers are not an approvable accessory structure on the properties pursuant to the requirements associated with Land Development Code, Chapter 2, Article 3, Section 25089. If there is not compliance, I will order a $25 per day fine be imposed beginning on March the 28th, 2023, and shall continue to accrue until compliance shall be achieved. I order cost in the amount of $23.56. As to case number 3, pavers.
Your Honor, I'm sorry, can I just make one correction to
Yes.
the order? The second reference to Chapter 2, Article 3, Section 2-50A9, I was just gonna delete that just because that is the section that.
That's
states-
right, I forgot to delete that.
Okay,
All
thank
right.
you, thank you.
As to case number 3, I find there is a violation of the Land Development Code, Chapter 1, Article 2, Section 1.1416A1, and that the respondent is ordered to pay the $100 citation as well as the associated cost, and shall comply with the code by March the 27th, 2023. Compliance shall be achieved by obtaining an approved permit for the pavers and pass final inspection, or remove the pavers from the property. Absent compliance, I order a $25 a day fine be imposed beginning on March the 28th, 2023, and shall continue to accrue until compliance has been achieved. Further, the respondent shall be obligated to contact the City of Ormond Beach Neighborhood Improvement Division to schedule a reinspection of the property to confirm compliance at the date thereof. Absent compliance, the city will be granted the authority to enter on the property on or about after April the 10th, 2023, and have the right to remove the unpermitted pavers from the property with all costs thereof, and to be assessed against the respondent. In addition, should the city remove and dispose of the aforementioned pavers, the city shall not be responsible for any damage or loss associated, and the cost is $23.56. As to the $100 fine on each case, I will waive 2 of the 100 and impose 100 for all 3.
Okay, Your Honor, and just one more clarification, I wasn't sure if you said it, on the paver recommendation, case number 22112246, you didn't mention whether or not the city, or I don't believe I heard it, that the city, could come onto the property.
Yes.
The second paragraph,
I did. If I missed it, it is appropriate in all 3 cases.
okay.
Anything else?
No, thank you.
And there's a 30-day to appeal to the Circuit Court of the 7th Judicial Circuit. That completes our hearing. Thank you all very much. We stand adjourned. Ms. Henry, you want to come up there a minute? Congratulations, you did a very good job.
Oh, thank you.
You did a great job.
Okay.
Ben is in here.
I doing all right?
Well, it's nice to meet you. Hi, Katherine. Hi, yeah. Oh, okay.
Can I have your name?
Yes, my name's Tommy Lee.
I'm gonna be a manager.
I work in the county enforcement department.
And who are your immediate supervisor?
Chris Mason.
Chris Mason?
Uh-huh.
You don't have any influence.
Don't you ever forget
I'm gonna write it down.
See, you're one that said,
You're more than welcome to.
recommend
I don't need your permission. You think that lady needs your permission for everything, don't you?
I'm gonna ask you not to step to me like that again, okay? I'd ask you, please do not step to me.
Stephanie, to you.
Thank you.
Another thing.
what was your name, sir?
You can get it from your
Well, he's asking, I'm not claiming that we're
I'm
trying
not
to.
with him, so what's your name, sir?
Tommy Lee, City of Ormond Beach,
Give an identification.
neighborhood improvement. There's no identification number.
Do you have an employee identification number?
Did I say it not loud enough for you?
You must not.
There is
Do you?
no-
It's a yes or no.
There is no employee identification number.
Wow, man.
Thank you.
Yeah, you're a peach.
I don't know what your problem is, sir.
I asked you your name. That
I
was
gave
it.
it to you, sir.
That was all
I
I
gave it to you.
Yeah, okay. That's all you did, I guess.
Yes, sir. I gave it to you.
Is that how you started though?
That's what it's returned.
Oh, so no.
Have a good
So no is the answer?
Have a good day.
That be the answer? No?
Have a good day, sir. We appreciate
I don't
you.
need you to tell me have a good day, buddy. Have the day that you deserve.
Stop. Jim, turn it off.
What do these,
He's another one that everybody's else down to.
they say?
Right there. I think I'm gonna leave it up on the things that way, Councilman River, that he can use it.
He is definitely the kind of guy who makes great YouTube content, isn't he? Right. You know, make him the most hated person of the day. You know, you're the reason there's a divide between the people and government, buddy.
You want that mic up there too?
No, just.
Will you leave it down there?
Chris got one for something.
Miss, what was your title?
Sure, where?
Deputy City Attorney,
Who's the gentleman?
Assistant City Attorney,
What was his name?
Scott McKee, and Margaret.
No, they're down at the park. Yeah. Good. Yeah. Here's the one way back for a second.
How about the other one? Anything on the other side?
That actually is there, right below